Hey everyone, welcome back. Today I've got something special lined up. 4 sovereign citizens in 4 different courtrooms. 2 are updates on cases we've covered before, and 2 are brand new. First up is everyone's favorite sovereign, citizen Eric Martin. If you remember, just a few weeks ago the court was ready to release him on a PR bond. But Eric couldn't keep quiet long enough to enjoy his freedom, so he's been sitting in jail ever since. Let's dive right in and see how things unfold for him and the others. Stick around. You won't want to miss this.
Good afternoon, Your Honor. Don Silva on behalf of the people, PA 7439.
Nicholas Darren on behalf of the defendant, Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could unmute yourself and state your name for the record.
Very good. Okay, I got it.
You got it.
All right, you hear me?
Yep.
All right.
So this is People versus Martin.
Yes, Your Honor. I have spoken with the complaining witness at the time. He would like to proceed with this case, and the people would ask to set it for a settlement conference before we go forward with trial to see if there's a resolution.
All right. And Mr. Darren?
I mean, Your Honor, I guess we're gonna proceed that way. I was hoping, I'll renew my motion from the last time. Mr. Martin's been incarcerated, I think it's like 62, 63 days now. Court rule is pretty clear. If he's in over 28 days, he should be released on a personal bond. Mr. Martin's just been sitting in jail on this matter. I mean, I guess from practical, I would imagine the court's going to give him credit for time served, regardless of what the resolution is on this matter. Considering he's done over, at this point, he's done over 2/3 of what his original sentence would be. We're not going to accept an offer on this, and I guess we'll just set it for a settlement conference then, if that's what sister counsel wants.
And Your Honor, it's I know this case has been going on for a while.
Personal bonds.
That's correct. The issue here is that him and the victim are brothers. They live at their family
First
home.
I want to deal with the whole bond thing, because
Yes.
his bond is $2,500 personal.
So I think the issue with that is I was having a cover last week, but per the notes, if you recall, you ordered him not to return back to the property because there's a no contact order in place. 2 weeks ago, when Mr. Brother counsel appeared for the first time on this case, I believe I agree. And that's when the bond was changed, but Mr.
Who changed
Martin.
the bond?
Judge Kirsten. Yes.
So, Your Honor, Judge Kirsten changed his bond, and then after some further statements were made, he changed his ruling to leave Mr. Martin in jail.
And that's because Mr. Martin made comments about returning back to the location, the home where the victim lives. And to my knowledge, per my conversation with Mr. Martin, the victim today, he indicated he'll be leaving the hospital, returning to that house tomorrow.
Right. All right. So I'm going to
I mean, I have no objection.
Mr. Martin, now listen, you understand, I wasn't here, but Judge Kirsten, the original bond was $2,500 personal. Then he set it at $2,000 cash because of the alleged violation that says it says need to set a hearing on violation ASAP. I don't know if there was I don't see anything whether there's an alleged violation of the bond condition. Is that right?
Not an alleged
Or the
violation.
alleged was
He
just,
made comments
he made a comment about it.
that he'll return back to the
So
house.
this is why something. All right, so you understand you can't go to that house while you're on that. That's while the bond's in place. You understand that? Stay somewhere else. You understand that?
No, I do not understand, and I gotta stand up. First, I have nowhere else to go. Okay, so that's why I must return back there, and I objected. No,
Are you sure you want to do that? Last time you fired up your crayon recycler, you ended up talking yourself out of getting released from jail. But I have to hand it to Eric Martin. He fully believes his own delusions and is absolutely stuck on stupid.
Listen, your objection is duly noted. You have very, very highly competent counsel. So, let's let your counsel speak on your behalf. And so he already did, he made a motion.
Well, I object to you speaking on behalf of that.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days and then you can just sit there anyway for it. Stop interrupting. Your Mr. Madera made a motion to set this for a personal bond. I'm gonna set your bond at $2,500 personal. No contact with the victim or the victim's home location. If you show up at that location and violate my bond, you could be held in contempt of court. Just want to make sure you understand that. I'm just telling you that right now. So I'm setting your bond at $2,500. I'm granting the defendant attorney's motion. And the bond's $2,500 personal, no contact with the victim, and no leaving the state of Michigan without the consent of the court.
I got something to say.
And you have a right to remain silent, and anything you say can be used against you, and you already have an attorney who's talking on your behalf, and I've already granted his motion and changed the bond to personal, so.
Hey, well, I have something to say in response to that.
See everybody at trial.
I have something to say in response.
We'll see everybody at trial. Mr.
Your Honor,
Darren,
we
do you have
say-
any-
response.
Mr. Darren, do you have anything else further?
Your Honor, are we gonna set it for a settlement conference, or are we just gonna set it straight for a trial?
Sure, I'll set it for a settlement conference, and then a week later it'll be the trial.
All right, Your Honor, I understand the court's position. I mean, if Mr. Martin wishes to make a statement on his behalf, I can only advise him that I wouldn't, but if Mr. Martin wishes to make a statement and the court wishes to hear it, I don't have any, I mean, I'm not gonna, I'm advising him not to say anything, but Mr. Martin, if the judge wants to hear it, if he's allowing it, then I'll step
Hey,
aside and let you state it.
Mr. Martin, I've already granted your attorney's motion to set the bond at $2,500 personal. So if you have some other statement you want to make, I'm just going to reassure you again that you have the right to remain silent. Plus, your attorney's already said that, hey, you know what, it's probably a good idea to just do so, but go ahead.
Yes. Like I said, I'm going to exercise my First Amendment right to speak, and I have a lot to say, so I ask that you don't cut me off or I'm done talking now. I object to the bond conditions and stuff. I can't be in my house. It violates my due process rights. I have nowhere else to go, and he's not the true victim. He's lying, saying he's a victim, but I told the cops when they arrested me that I was the victim. And so we have an equal protection clause violation.
All of that'll be the subject of the trial itself, so we'll hear everything you have to say about that at trial. Your objections duly noted. But that doesn't change my bond.
How much do you want to bet that Eric Martin won't follow his bond conditions? I'm calling it now. He'll be rearrested within a month. Eventually, all these bond violations and his refusal to follow court orders are going to catch up with him at sentencing. Now, let's move on to our next brain donor, which takes us to Kanato. This is a continuation of a case involving a sovereign citizen, Karen, I've covered before. She's been testing the patience of a very explosive judge. Here's a quick snippet from the last hearing to get you all caught.
I have a question.
In this blue chair.
Do I have the
Sit
same,
down.
Do I have the same rights?
You want me to hold you in contempt? Sit down. In that blue chair.
Do I have the
Sit
same
down.
rights there?
One more time. Sit down. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs.
I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No,
Would
I do not recognize anyone in this court.
Okay, well,
I
that's
don't
too bad.
recognize you or the bailiff or anybody else in this court. Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis, non de guerre.
I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and give a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court, and I'll have you arrested. You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it?
Unfortunately, she didn't. Keep in mind, she's only facing 2 minor traffic charges with a total fine of just $300, no jail time. But remember that as you watch her do everything imaginable to end up getting herself arrested.
Court is now on the record in City of Conneaut versus Amber McHenry, 24 TRD 819. Ms. McHenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor, on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McHenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McHenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McHenry is now turning herself in on the warrant. She is in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR, like 0800 something. And
24 TRD 819.
819. Okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
That sovereign citizens are an endless fountain of uneducated entertainment, and there's no way anyone could be that clueless. Right, Karen? But here's the thing. You don't have to identify as a sovereign citizen to act like one. All it takes is a complete lack of functional brain cells and a tendency to run headfirst into brick walls. And right now, you're doing both. Especially with the paperwork you've been filing, which includes
that you filed, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official in this case who is acting as a public servant to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. I need the accounting. Please, for the record, let it be known that you exited.
I
while
did.
asking.
I exited the courtroom and asked a police
Who
officer and
is-
probation
Who has
officer
the
to come
indemnity
by.
bond? Where is the bill of particulars?
The
Because I
bond is
did not
being,
receive it.
the warrant is being executed. You're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to
either.
the jail now.
Why am I being arrested?
Take her down
For
to
what?
jail.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest. No, This is a false arrest. This is kidnapping. They're violating my rights, my constitutional rights. I put in...
I thought the Constitution didn't apply to you.
The Constitution applies to every living man and woman.
Yeah.
You are violating your oath, Mr. Iarochi.
You're going to jail, Miss McHenry. Remember what I said at the beginning of this video? Her maximum possible fines totaled just $300 with absolutely no jail time. I guess I didn't realize that being a constitutional freedom fighter meant you'd be fighting against your own freedom. Now, on to our third hearing. This time, we're heading down to Texas, where a man bought a foreclosed home only to discover a sovereign citizen squatting inside. All right, let's jump back in and see how this one
Frederick Falcon versus James Larry Warnke.
Give this to the judge, sir.
Mr. Falcon, this is your case. So what is it you're asking for the court?
We purchased the house through tax deduction, and we're just asking occupants to vacate the property.
A tax foreclosure sale?
Yes, sir.
Okay, I see a copy of your sheriff's deed. You had it attached to the petition, and you purchased this on the first Tuesday of November, is that correct?
Yes, sir.
Okay, and after you purchased the property, I guess you realized it was occupied, and you served a notice to vacate. It says hand delivered.
Just with us know.
And by hand delivered, do you mean you actually handed it to him?
We tried to. There's a lot of signage up at the property. It's very intimidating. Gun, don't trespass, knocked on the door, left the letter.
Where did you leave it?
Front door.
It says hand delivered. Okay, but you didn't hand it to anyone,
No one refused to answer.
sir?
No one answered. No
No
one
one
answered.
answered. So you just stuck the notice on the outside of the
Stuck
door?
in the door.
In the door, not on the inside of the door.
Through the crack.
Through the
Went
crack.
in the house. Went in the house.
Okay, let me hear from you.
I never did see it,
Okay,
but
what's your opposition to this eviction?
I've got an unrebutted affidavit I sent to the Albert Uresti tax assessor around 2021. He didn't rebut it. So an unrebutted affidavit, as far as I know, it's a maxim of law. It stands as the truth of the matter. The truth of the matter is I don't know property taxes because I declared my house.
Because you claim your record is squeaky clean and aroma-free doesn't make it true. An unrebutted default on the loan is still a default, and private property isn't magically exempt from the
And private property is not subject to, only real estate is subject to income, property taxes. So that's what I couldn't understand, how they just went around an unrebutted affidavit like it was nothing.
Okay, so what you have is an issue of title, and I don't have authority to hear any issues of title. Okay? Not within my jurisdiction. You'd have to do that in a different courtroom, okay? But for today's purposes, you got very lucky because the way you served the notice to vacate doesn't comply with Texas law. You can't just stick it in the door.
Okay.
You have to put it on the inside of the main entry door. You have to look at Texas Property Code,
What do we do?
Section 24.
What if we do if he's not answering or not?
Well, that's what I'm telling you. Either hire an attorney or read Texas Property Code Section 24, and it's very specific as to how the notice has to be delivered. Now, the law is clear. It has to be delivered in certain ways, but it doesn't say they have to actually receive it. Okay?
Yes, sir.
Because I've had people say, I emailed it. Well, that didn't count under the law. You know, there's ways you have to serve it. And based on your testimony as to how you served it, it's not one of the legal ways to serve the notice to
Would I
vacate.
be able to serve the notice now?
The question is, no. You can't serve him now because your initial service was improper, and this case is getting dismissed. That means you'll have to restart the eviction process from scratch. Today is day 0. Next time, make sure you strictly follow the procedures in Texas Property Code 24.05F. But honestly, all of this might be pointless because the sovereign citizen in this case is about to do something we rarely see. He's just going to give up.
Case is going to be dismissed because the notice to vacate was not properly served, and you're gonna have to start over. And so I would suggest we speak with an attorney about your title issue, if that's gonna be your.
I've got
defense.
another unrebutted affidavit here called the Executor's Entitlement Land Title, where I own the land
Okay,
under that
Again,
house.
I cannot determine who owns the land. I can only determine who has the superior right to immediate possession. That's the only issue before this court.
Well, hey,
That's the only issue I can address.
let me stop all this then. Let me just give him the house. I've already vacated. I've got another place to live. And I just want to settle this. After the reset that's coming up, we're gonna have a global reset. I'm gonna get the house back because I own the land.
Okay.
I'm a sovereign principal. I'm not a US citizen. US citizens can't own land.
Yes,
On a deed, a Texas deed, it says they're a tenant in peaceful possession. A renter, I'm not a renter. I own the land. And I don't own the house. He supposedly does because they just went around and my
Yes, sir.
affidavit like it didn't exist.
I have heard those arguments, sovereign citizen, multiple times.
No, sir. I didn't say sovereign citizen. I said a sovereign principal.